If you are buying a home or already own one, there's a critical legal distinction that could cost you everything. I'm Tiffany Weber, a real estate attorney who's handled thousands of closings, and I've seen people put their investment at risk because they didn't understand the difference between title and deed. In the next 6 minutes, I'll explain exactly what title and deed mean, show you the 3 most expensive mistakes people make when confusing them, and give you a simple framework to protect your biggest investment. This isn't just legal theory. This is about protecting your family's future. Let's dive in. Let me start with a quick story. Last year, a couple came into my office in tears. They'd purchased what they thought was their dream home 3 years earlier. They'd done everything right, or so they thought. They had a deed with their names on it, framed on their wall, but now someone else was claiming ownership of their property. How is this possible? Because while they had a deed, they didn't have clear title. And that distinction is what we're talking about today. Here's the simplest way to understand the difference. Title is a concept. A deed is a document. Let me say that again because it is crucial. Title is a concept. A deed is a document. Title refers to your legal ownership rights to a property. It's not something that you can touch or hold. It's the bundle of rights that gives you the legal authority to use, occupy, sell, lease, or mortgage your property. A deed, on the other hand, is the physical legal document that transfers those ownership rights from one person to another. It's the piece of paper that serves as evidence of the transfer of title. Think of it this way. If ownership of your home was a championship, title would be winning the championship, and the deed would be the trophy they hand you afterward. The trophy proves that you won, but it's not the same as the victory itself. Now, before I show you the 3 most common and costly mistakes people make when confusing these terms, I want to address something important. Even if you're working with a real estate agent, even if you have a lawyer handling your closing, even if you've bought property before, this information matters to you. Why? Because ultimately it's your home, your money, and your future on the line. All right, here's mistake number 1. Assuming that you have a deed means you have clear title. Remember that couple I mentioned? They had a deed, but they didn't have clear title. Here's what happened. The previous owner of their home had a judgment against them that created a lien on the property. And this lien wasn't discovered during the title search because it was filed under a slightly different spelling of the name. When the creditor finally tracked down the property, they came after my client's home, even though my clients had a deed showing they owned it. Because that lien attached to the property before my clients bought it, it followed the property to the new owners. This is why title insurance is so critical because it protects you against these hidden claims. But many people decline owner's title insurance because they think, I have the deed, so I'm protected. And that is a potentially devastating mistake. Now, there's a specific way to check if your title is actually clear, which I'll share with you in just a moment. But first, let's look at the second major mistake. Mistake number 2 is confusing the types of deeds and the protections they offer. Not all deeds are created equal. There are several types and each offers different levels of protection. A general warranty deed offers the highest level of protection. The seller guarantees that they have clear title, that they will defend that title against all claims, and they will compensate the buyer for any loss. A special warranty deed only guarantees against issues that occurred during the seller's ownership, not before. And finally, a quitclaim deed offers the least protection. It simply transfers whatever interest the grantor might have with no guarantees they actually own anything at all. Let me give you a real example of how this can go wrong. Last summer, I had a client who acquired a vacation property without the use of an attorney using a quitclaim deed because the seller was a friend who offered a great deal. My client thought he was saving money by skipping the formal process. 6 months later, he discovered that his friend only owned 50% of the property. The other 50% belonged to the friend's ex-spouse from a divorce settlement. He only owned half the property and had to pay the ex-spouse to buy out their interest. That great deal ended up costing him an extra $300,000. I'll show you exactly how to determine what type of deed you have or need in just a minute, but first let's cover the third critical mistake. Mistake number 3 is not understanding how title affects your ability to sell or refinance. Many homeowners don't realize that title issues can prevent them from selling or refinancing, even if they have a deed in their name. I had a client who tried to refinance her home to take advantage of lower interest rates. The refinance was denied because the title search revealed that when she and her husband had divorced 5 years earlier, he never signed a deed removing his name from the title. Even though she had the house in the divorce settlement and even though she had a deed with her name on it, she didn't have clear title. She couldn't refinance until her ex-husband signed off, which gave him unexpected leverage to try to demand money for his signature. Now, here's what you really need to understand about title versus deed. This is the part that most people miss, and it can cost them thousands. Title is dynamic. It can be affected by events that have nothing to do with you or your deed. These are tax liens, mechanics liens, undisclosed errors, forged documents, errors in public records. All of these things can create clouds on your title, even years after you purchased a property with a perfectly valid deed. On the other hand, your deed is static. It is a snapshot of a transaction at a specific moment in time. But your title is constantly vulnerable to outside claims and legal challenges. This is why I tell all my clients that your deed is only as good as the title it's transferring. So, how do you protect yourself? Here's my 3-step framework for making sure that you truly own your property. Step 1, always get a professional title search before purchasing property. This isn't just about checking who owns the property now, it's about tracing the chain of title back decades to ensure there are no breaks, gaps, or competing claims. Step number 2 is understand what type of deed you're receiving. In most residential transactions, especially in North Carolina, you should receive a general warranty deed. Accept nothing less unless you fully understand the risks. And step number 3, purchase owner's title insurance. This is different from the lender's title insurance that your mortgage company requires because owner's title insurance protects your investment, not just the lender's. It's a one-time premium and it provides protection for as long as you or your heirs own the property. Now, if you already own a home, you might be wondering, is it too late for me to check my title or get title insurance? The answer is no, it's not too late. You can still order a title search even years after buying your property. And given what's at stake, it can be worth doing. If you're in the process of buying a home, make sure you understand exactly what type of deed you're receiving and what title insurance covers. And if you're selling a property, be clear about what warranties you're offering in your deed because they could come back to haunt you years later. Now, you might be thinking this all sounds complicated and expensive. Don't worry, if you're not a legal expert, you don't need to be. You just need to know enough to ask the right questions and work with professionals that have your best interest at heart. And yes, there are costs involved with title searches and title insurance, but compared to the potential loss of your entire investment, these costs are minimal. It's like questioning the cost of a parachute when you're about to jump out of a plane.
You have a parachute? You don't have a parachute!
Understanding the difference between title and deed isn't just legal trivia, it's essential knowledge for protecting what is likely the biggest investment of your life. Title is your legal right of ownership, and the deed is the document that transfers that right. Your deed is evidence of a transaction. Your title is what gives that transaction meaning. If you remember nothing else from this video, remember this. Never assume that having a deed means you have clear title. Always verify, always protect. If you found this information valuable, please hit the subscribe button. I create videos like this every week to help homeowners and buyers navigate the complex world of real estate law in plain English. For those of you in North Carolina looking for more personalized guidance, my law firm Thomas & Weber focuses on real estate closings and title issues, and the link to our website is in the description below. Thank you for watching, and remember, when it comes to your home, knowledge isn't just power, it's protection.